Thank you.
Turn going. That'll go to green.
Gotcha.
And
Right.
and then that comes.
Hello. The first item on the agenda is to elect a chair for the hearing. So could I have a nomination for chair, please? Nick Wells. Yeah. Okay, seconded. Okay. All agreed? Yes. There's Councillor Wells in the chair then. Thank you.
Thank you. Item 2, members' interests. Do members have any interest to declare this afternoon?
No.
Thank you. So welcome all to the meeting. I'm Councillor Wells, Chair of the Licensing Subcommittee hearing. Before we start, I'd like to remind you of a few housekeeping arrangements. If you wish to speak, please can you indicate that you wish to do so. Technically, to speak, you press the middle button of your microphone, which will turn green. The top part of the mic will turn red. When you finish speaking, please press the button again to move it on. In the event of a fire alarm sounding during the meeting, please stand and follow the meeting administrator to the fire evacuation point outside the building. The meeting is being filmed on the Council's YouTube channel for live and subsequent broadcast. The whole of the meeting will be filmed except where there are confidential or exempt items. Thank you. So in the room this afternoon at Pathfinder House, we have the following: Councillor Banks and Councillor Buttel, members of this subcommittee. Luke Elford, the Council's legal advisor on my right. Democratic Services. So I'll now ask officers from the licensing team to introduce themselves, please.
Thank you, Chair. I'm Michelle Bishop. I'm the Licensing Manager.
I'm Sarah Marden. I'm a licensing officer.
Thank you both. Would those representing the applicant please now introduce themselves? Please state your name and in what capacity you are here to represent the applicant. Thank you.
Hi, Chair. William Della Refice. I'm a licensing officer acting in my capacity as a responsible authority.
Thank you, William. Any others? No. Thank you.
Hi, I'm Kate Penn. I'm Environmental Health Service Manager at the District Council. Thank you.
Thank you, Kate.
Good afternoon, Chair. PC Paul Hawkins, Cambridgeshire Police, representing the licensing aspect.
Thank you.
And good afternoon, Chair. I'm David Dadds. I'm counsel and I'm representing the premise licence holder. And the premise licence holder, or the director, is to my right. Can I just check that you're happy for me to record the meeting on my device here?
It shouldn't be necessary to record it because it's being live streamed and recorded on YouTube as well. So I don't think you should need to take a separate record of your own.
Yes, I'd like to have a separate record. It transcribes the whole meeting as well.
Are we? Okay, we're prepared to allow that.
I just think out of courtesy, I always like to let you know
of course,
as well.
Thank you.
Thank you.
That's appreciated. Thank you. So this is the point where interested parties introduce themselves. You just have done so, so I didn't catch the gentleman on your right. Thank you.
Hi, I'm Domenico Ricciardi from Lancaster Lounge.
Thank you. And other interested parties, please, behind you. Thank you.
I'm Dale Freeman. I'm a customer of the Lancaster Lounge.
I'm Karen Clark, also a customer of the Lancaster Lounge and live close by.
I'm Adrian Aylett. I'm a local resident.
Sorry, could you just say your second name again, please? Aylett.
It's Aylett. A-Y-L-E-T-T.
Thank you very much. Okay, I think I've covered everybody now. Thank you. So item 4, this is the licensing subcommittee procedure that I need to read out. You would have received within the hearing papers that were circulated to you a copy of the licensing subcommittee procedure. The hearing will commence under this procedure. Any representations that have been made should be relevant to the 4 licensing objectives, which are the prevention of crime and disorder, public safety, the prevention of public nuisance, and the protection of children from harm. As you will see, in the interest of fairness, the procedure provides for an equal amount of time for the applicant, responsible authorities, and interested parties to address the subcommittee. This is usually 20 minutes, which in the case of interested parties is shared between those in attendance. However, I can use my discretion. On this occasion, I would allocate all parties, the applicants, the responsible authorities, and the interested parties 20 minutes each. So the interested parties would have 1/3 of that. Do any parties hear any questions or clarifications that they need at this stage? This should relate to the procedure only. Mr. Heads?
Yes, it may not be here at this procedural point, but when you're ready, I'd like to make an application for an adjournment, please.
That's fine. We will hear that.
Thank you.
Just after we've finished hearing the procedure.
Thank you. So that concludes my reading of the procedure. So I'll now pass to a legal advisor, Mr. Elford, as the next step. Thank you.
Thank you very much, Chair. As you've indicated, Mr. Dadds, you have an application that you wish to make, and I'll let you make that in just a second. The way that we're going to deal with this is Mr. Dadds is going to make his application, and then we will afford all of the parties a right of reply as regards the application, after which the committee will retire and make their decision. And subject to that decision, the hearing will either go ahead as planned or there will be an adjournment at Mr. Dadds' request, but that will be at the discretion of the committee. So, Mr. Dadds, over to you.
Thank you. So, Chair, actually, before I start, can I say that obviously I know our thoughts and prayers would be those of any victims of yesterday's or the weekend's incident, and I'd like to obviously just note, I'm sure we all do, that the first responders and public that help, even though in your district, where our thoughts and prayers with them today. I should say that before we start a public meeting. In relation to my application, it has two, in effect, components. It's the first is that I'm asking for this to be adjourned. So administratively, those who've made representations are entitled to be here and to be notified of the hearing and the procedure. You may not be aware, Chair, members, but there have been at least, I understand, at least 50 local residents whose representations have been excluded from being included as representations in relation to this application. And I have one, for example, on the screen here from Chloe. And Chloe wrote in good time, and she set out her name and address and postcode, said that she'd visited the premises on a number of occasions, and that she'd never experienced any antisocial behaviour or any noise. In fact, she's always had a good experience, warm and friendly environment, and she supports the premises and would like it to remain in its current form. That is a valid representation without any... Sorry, I'm making a representation. I know a legal advisor should be neutral, provisional, and not have their own opinion. So you shouldn't be intervening in that way.
Mr. Dadds, you are perfectly permitted to explain and make your application. It is not for you to tell the licensing authority that representations should have been accepted or not. Please make your application, but if you'd like to not continue furthering those points that you've just made, we would be grateful.
Mr. Chairman, members, I didn't realise that free speech or open speech was restricted here at this council. I'm a legal representative, and without fear or favour, and robustly put my client's case across. There is a resident that I've just said here, Chloe, and there are others who have made relevant representation, and I'm entitled to say that they are relevant, whether the local authority agrees with me or not, and I shouldn't be prohibited from saying so. That is a valid representation in law, because it explains that their experience that there's no antisocial behaviour or noise. To be a relevant representation in the law, it says it must not be either vexatious or frivolous, which it isn't, and it must address one or two of the impacts on the licensing objective, which it does, about noise nuisance, prevention of crime disorder. So from our representation, that's a valid representation. Now, we understand at least 50 of these representations have been rejected, and we say that is wrong. Those residents, no different to you've all experienced, I expect, when someone casts a vote. If it's a spoiled ballot, an officer will make a decision, a returning officer, whether it is a valid one or not, but they will consult with those who are impacted by it. No different to us. If there are 50 representations in support of us, we say, be entitled at least to see what those representations are. If the council operates under the principles of the Nolan principles, open, transparency, through leadership, honesty, why aren't they and why can't they be disclosed? And likewise, Chloe wrote to us saying, I want to be here. I want to tell the committee about her experience. And she's being denied that opportunity. And that is highly prejudicial to us as a premises. We are subject to review from the licensing authority, and the licensing authority seems to have excluded. Now, I don't know if there's a separation of those responsibilities, but clearly the licensing authority are making a decision to exclude over 50 people on an application that the same authority is bringing a review. And so therefore, in those instances, extra care should be taken to deal with the perception of bias, making sure that things should be open and transparent and fair. And we say that is highly prejudicial to us. Obviously, your legal advisor has formed his own view, maybe, I don't know. But I would ask that actually as members that you make that decision, whether you think it's right that members of the public are being excluded. And obviously any advice that you receive should be provisional until it's repeated here in case I want to comment on it. But on facts, you decide. On law, you should hear submissions on both, and I'm entitled to give you an opinion on law. The other matter that we have concerns with is that we want to have the opportunity to prepare a case even further. I know it was, and I accept that it was a fairly late request last Thursday to ask for a bit more detail of the 25 complaints that were referred to by the licensing authority. Now, we understand that those representations are hearsay because they say that they have been informed by Environment Health or another party of those complaints. Now, I've been greatly assisted by your legal advisor this afternoon in telling us that out of the 25 complaints, there are 5 separate complainants. However, I would like the opportunity to have more details about which complainants have made which complaint. I appropriately redacted complaint A through to E, and the dates and times, because my client understands or believes that pretty much up until April this year, there was only one complainant, and that there are a number of complaints over the summer, I believe from multiple individuals, but maybe to do with the weekend or bank holiday event. And that may be relevant to how we present our case, having afforded more time. On its own, that wouldn't have been sufficient, I think. I probably would not have made an adjournment on that alone. However, but given the lacking of the representations, the exclusion, and the right to have a fair hearing and make sure that we can call or have other residents come and tell you about their experience of living nearby, what they experience, I would ask that this matter be adjourned so that those individuals can be informed, or someone can take a view, maybe even you members, look at the representations and take a view yourself whether they are valid or not. That is my request for an adjournment.
Licensing authority.
Hi, Chair. I take on board Mr. Dadd's comments. I accept that he admits that the request was made very late with almost less than 48 hours notice to compile a year's worth of information, which is just not feasible. Section 182 of the guidance does specifically state that representations do not need to produce a recorded history of complaints. And the fundamental piece of information of why I don't think this adjournment should occur is that I have made it very clear in my application for review and my supporting statements that I've called this review due to unlicensed activity and a breach of conditions. As I've clearly stated in that, the complaints are supporting evidence. So the mere presence of complaints is what I'm referring to. I haven't said that I'm calling a review because this complaint has occurred, this complaint has occurred, this complaint has occurred. I have called the review due to the unlicensed activity that has been found on inspections and visits to the premises. The complaints may have highlighted that, but that is not the cause of the review. And that's all I have to say today, Chair.
Environmental Health.
So I'm largely in support of what my colleague has already said. Thank you.
Please.
Thank you. Yeah, I mean, I agree with what William said. However, I'm aware that Mr. Dads will probably go for an appeal if he doesn't get his own way, because that's his normal way.
Thank you, Officer. Interested parties. Let's start with. Forgive me, names. Mr. Freeman. Yes. What do you have to say about the adjournment, sir?
Thank you very much. Thank you. It is clear that the owner, Dominic, has acknowledged his mistakes and shown genuine willingness to rectify them.
Really sorry, sir. This is just about the question of whether or not there should be an adjournment to this hearing.
Oh, beg your pardon. I'm sorry. I'm very sorry. Well, I can only support the advice that the solicitor for Lancaster Lounge is offering.
Sure.
Thank you. Sorry about that.
And Ms. Clark?
Yes, I support as well.
Last but by no means least, Mr.
Yeah,
Aylett.
obviously I do not support the adjournment. I'm a managing director for a company. I've taken half a day off. I think the cost of this to the community is quite large. I'm a council taxpayer. Do not see why we should go through this rigmarole again. And so I'm not in favour of it.
Mr. Dadds.
Could I have a brief opportunity to respond to what were the objections to the application?
No, Mr. Dadds, you've made your application. We've heard from everyone, given everyone a chance to make their feelings known. The committee are going to retire to make their decision in respect of your adjournment request. You don't have the right to reply.
Yeah, I'm being refused a right reply. Thank you. I'll make it noted.
Good afternoon once again. Councillors have worked with the legal advisor, Luke, to determine whether we feel that an adjournment is appropriate or not this afternoon, and we have made the decision that we think an adjournment is not appropriate. So next I'll ask Luke to expand on that decision. Thank you.
Thank you. Just for the purposes of everyone's notes, I've provided the following legal advice to the subcommittee, that the test for assessing whether or not submissions are relevant, and if so, whether they are frivolous, vexatious, etc., is set out in the Licensing Act 2003. The decision as to whether or not to accept submissions as relevant representations rests with the licensing officer processing the application. Where submissions are rejected, the individuals concerned should be notified by the licensing authority. Those submissions would not be included in the agenda papers, nor is there a specific right within the Licensing Act 2003 that they be given to the licence holder. It is not for the licence holders to suggest that a particular individual's submissions should have been included within the agenda papers. Should an individual concerned wish to challenge that decision, then there are mechanisms by which they can do so. In relation to records of complaints, the committee were appraised of the guidance which suggests that complete records need not be disclosed. Adjournments may be granted where it is the interest of justice to adjourn the proceedings. The committee heard an application from Mr. Dadds on behalf of the premises licence holder for an adjournment of this review hearing. The basis of Mr. Dadds' application was twofold. First, responses to the licensing authority which had been refused by the licensing officer against the criteria within the Licensing Act 2003 had been refused incorrectly. Second, that complaints recorded by the licensing authority in environmental health had not been sufficiently particularised. The other persons supporting the premises licence holder supported Mr. Dadds' application. The committee heard from the applicant who opposed the application for an adjournment. This was supported by the other responsible authorities in attendance, as well as the other person in support of the review application. Having considered the submissions for and against the adjournment, the committee determined to refuse Mr. Dadds' application. The hearing will proceed as proposed this afternoon. The committee understand that the process for the assessment of submissions and whether or not they can be considered relevant representations rests with the licensing officer processing the application. The committee understand that some submissions were refused because they did not meet the criteria within the Licensing Act 2003. The committee are not minded to go behind the licensing officer's decision-making in respect of these submissions. The committee noted that there were a great number of submissions in this case, and even though a number were rejected, many were accepted, including plentiful representations in support of the premises licence holder. As regard the second limb of Mr. Dadds' submissions, the committee noted that even by Mr. Dadds' own admission, his request for details of the complaints was made late in the day. The committee understands that the agenda papers were provided some time ago and that Mr. Dadds' request could have been made earlier. Furthermore, that efforts had been made to provide Mr. Dadds with the total number of complaints and the dates of those complaints. The committee felt was sufficient to allow Mr. Dadds to address the issue of the complaints, which, as pointed out by the applicant, was not the driver of the review application. These are the committee's reason for refusing the adjournment request.
Thank you, Luke.
Case management. A bit of case management. Case management.
You've
Sorry. Done the procedure, haven't you?
Yep. So our next thing we must do.
So I'll come and do case management. Thank you. Okay. Just before we move into the licensing officer's report, for the purpose of everyone here, just want to do a little bit of case management, if we may. First of all, just want to check who intends to speak this afternoon, and just make sure. Applicant, you are speaking, yes. Environmental health, yes. Yeah, and the police as well. Mr. Aylett, you intend to speak too, do you? Do you have a rough indication of how long you might take? Okay, sure. Mr. Dadds, naturally, I'm sure. How long do you think you'll need, Mr. Dadds?
About 2 hours? No, about 20 minutes.
About 20 minutes.
But I would say I would like to be able to, through you, Chair, to ask questions of the responsible authorities if possible.
That's part of the process.
About 20 minutes, I would say.
That's part of the process, so that's absolutely fine. So, just in terms of documents, all of the documents, has everyone got the agenda papers and the agenda packs? I'm seeing nods around the room. And then that includes Mr. Dad's submissions from this morning. We just want to make sure everyone has all the paperwork. Mr. Aylett, have you got everything? Okay. Could we give Mr. Aylett a copy of Mr. Dad's submissions so that he has them? Mr. Aylett, these were circulated before the hearing. Apologies they didn't get through to you. No, that's absolutely fine.
And Chair, the reason why I've been able to say that my representations won't be more than 20 minutes because I put most of them down in writing, so I thought that may assist you.
Thank you. So, for the purposes of everyone here, the committee will listen to all of the evidence and note.
So members have had it by email, but they haven't had this paperwork.
Have you not had it printed out?
No.
Have you read those? The submissions? Okay. Are you content if we read them afterwards?
Yes.
I mean, you're going to speak to them anyway.
Yeah, I'm content that I'll speak to salient points, and if Chair and members, if when you retire, a printed copy could be given to you, I'd be grateful,
fine.
and I'd be quite happy with that.
Sure. So, no decision has been made yet. I just want to highlight to everyone, these are emotive proceedings. We understand that people may feel emotional about things, be it that their business or their residence. We're not going to tolerate any personal attacks. So please can people stick to the facts? And ultimately, just as a warning, the committee can ask people to leave if they are disruptive. A second note, just in terms of licensing and planning. Licensing and planning are separate regimes. Planning is concerned with how land is used, licensing with how licensable activities are provided. Both regimes can be enforced, albeit separately. We here today, this committee, are concerned with licensing and licensing only. So references to planning and planning conditions should be few and far between, please. Questions, when we come to that point, all questions please through the chair rather than direct across the room. The committee have read nearly all of the papers that they have. We don't need people to repeat themselves or to read out their representations. In terms of your representations, you are entitled to amplify what you have said in your representations, but I'm afraid you cannot raise new material that has not already been before the committee. And this is also true of documents. If anyone had any documents that they were thinking of producing at the hearing. In terms of our decision making today, the committee will retire and make the decision, and the decision will be provided within 5 working days as per the regulations, and the decision will be circulated as soon as possible. That's all from me for now, but if anything crops up during the hearing, I will let you know.
Thank you very much, Luke. So we will now move on to item 5, the hearing itself. So I'll now invite the licensing officer to present the application. Thank you.
Thank you, Chair. Okay. Huntingdonshire District Council, as the licensing authority, has received an application to review the premises licence from Huntingdonshire District Council Licensing Officer William Deferetti in his capacity as the responsible authority under the Licensing Act 2003. The for premises licence number HDC/PRE00890. This refers to the Lancaster Lounge at 152 Main Street, Yaxley, PE7 3LB. The application was received on the 10th of September 2025. As required under the Licensing Act 2003, a notice of the application was advertised on the Council's website, and blue notices were displayed at or near the premises from the 11th of September 2025. The 28-day consultation period ended on the 8th of October 2025. A copy of the application for review, along with supporting documentation, is attached to this pack as Appendix A and A1 and A2. The current premises licence holder is Lancaster Lounge Limited, the sole director of which is Domenico Ricciardi, forgive me if I've said that wrong, who is also the designated premises supervisor. A copy of the current premises licence is available at Appendix B in this pack. And as for background, the premises are 152 Main Street, Yaxley. For many years was the Royal Air Force Association Lancaster Club. This benefited from a club premises certificate, licence number HDC/CPC 00011. This ceased operating in November of 2020, and the club premises certificate was surrendered. The premises remained empty and unused until January of 2022, when the first planning applications were submitted to refurbish and reopen the premises. In January of 2024, the application to grant a new premises licence was received and processed, and in March of that year, the licence was granted following a hearing of the licensing subcommittee. On the 6th of April 2024, the Lancaster Lounge opened to the public. Since the premises licence was granted, there have been several minor changes to the licence, namely in June of 2025, a minor variation. This was to include off sales on the licence as an activity and to update the internal plan. And again, in July of 2025, a variation of the designated premises supervisor was applied for to replace Simon Baker with Mr. Ricciardi. During the period for representations, comments have been received in support of the review application and in support of the premises. Representations in support of the review application include 3 representations from responsible authorities, and these are as Appendix C in your packs, and 3 representations from other persons, and these are Appendix D. Also, during the period for representations, 54 valid representations were received in support of the premises, and these are seen at Appendix E. In addition, a petition was submitted in support of the premises from the premises itself, containing 95 signatures. This petition is attached at Appendix F. Not all matters raised within the representations may be relevant matters for consideration under the Licensing Act 2003. Any person who has submitted a relevant representation is entitled to address the licensing subcommittee at the hearing and ask questions of any other party appearing at the hearing. The licensing authority must carry out its function under the Act with a view to promoting the licensing objectives. Each objective has equal importance. The objectives are the prevention of crime and disorder, public safety, the prevention of public nuisance, and the protection of children from harm. The subcommittee must also have regard to the Statement of Licensing Policy, any statutory guidance issued under Section 182 of the Licensing Act, and the Human Rights Act 1998. The Council must also fulfil its obligations under Section 17 of the Crime and Disorder Act 1998 to do all that it reasonably can to prevent crime and disorder in its district. In making its decision, this application must be determined on its individual merits, having regard to the representations and supporting documentation as part of the report, along with additional information considered relevant at the hearing. As part of the decision process, the subcommittee is required to give its reasons for any decision arrived at. Where the licensing authority considers that action under its statutory powers is appropriate, it may take any of the following steps. Modify the conditions of the premises licence, which includes adding new conditions or alteration or omission of existing conditions, for example, by reducing the hours of opening or by requiring door supervisors at particular times. B, exclude a licensable activity from the scope of the licence, for example, to exclude the performance of live music or playing of recorded music, where it's not within the incidental live or recorded music exemptions. C, to determine to re-regulate music activities currently exempt from regulation by the Live Music Act 2012 in conjunction with A or B above. D, remove the designated premises supervisor, for example, because it considers that the problems are a result of poor management. E, to suspend the licence for a period not exceeding 3 months. F, to revoke the licence, or G, to take no action. Any decision made by the licensing committee must be reasonable and proportionate and promote the licensing objectives. Thank you.
Thank you, Sarah. Do any members of the licensing subcommittee have any questions for the licensing officer? No. Any questions? Thank you. Does the applicant or their representatives have any questions? Do any of the interested parties have any questions for the licensing officer? That's questions only at this stage, please. Okay, thank you. I will now ask the applicant and their representatives to address the subcommittee for no more than 20 minutes and to call any witnesses if relevant.
Thank you, Chair. You'll be pleased to know I don't have as much to say as a lot of it's been covered off at the start of this hearing. Some things have been discussed. I would like to just make it clear once again that the reason why I've applied for this review is due to the ongoing breach of licence conditions and the persistent unlicensed activity that has occurred at the Lancaster Lounge. The accumulation of complaints simply serves as further evidence to support my concerns. With regards to my review application, supporting statement and the evidence submitted alongside that, I would like to draw the committee's attention today to a few key points from these submissions. You'll have seen from my supporting statement that there have been several instances of unlicensed activity from the Lancaster Lounge that have come to our attention, and these include the performance of live music in July 2024, unlicensed off-sales between April to June 2025, the sale of alcohol after 2300 hours in August 2025, and the provision of late-night refreshment between 2300 hours and 2346 hours in August 2025. As detailed in the application for review and my supporting statement, Mr. Ricciardi has been made aware several times of the conditions of his licence and has been informed that improvements need to be made. In particular, the requirement for a written risk assessment for the use of SIA door supervisors and improved training. The CCTV footage that I've submitted also clearly shows from the inside footage that Mr. Ricciardi has stood at the front of the bar being approached by a female customer at 23:04 hours, who then proceeds to order and purchase 2 alcoholic drinks. Another 2 customers, male and female, also walk up to the bar seconds later. Mr. Ricciardi can be seen talking and using hand gestures to the bar staff and then points to the 2 customers. As Mr. Ricciardi walks off, he pats the male on the shoulder. Once the bar staff finish the drinks for the first customer, the staff member then proceeds to serve the other 2 customers. The CCTV footage covering the outdoor garden area shows customers in the garden as late as 9 minutes past midnight and staff present in the garden as late as 22 minutes past midnight. Mr. Ricciardi can be seen in this footage talking to customers outside 2300 hours. Other key points from the footage show an outdoor pizza oven in use until 23:46 hours and people present within the premises until the footage itself stops at 1 minute past 1 in the morning. Even though Mr. Ricciardi was aware of several ongoing complaints raised to ourselves in environmental health, Mr. Ricciardi's decision to host this Ibiza Sessions event with little to no controls in place and capped with an impromptu fireworks display has showed a clear disregard for the conditions of his license and to the residents surrounding him. Despite several instances of intervention directly with Mr. Ricciardi, both as the license holder and as the designated premises supervisor, he has also continued to show a clear disregard to the advice and support I have given to him over the last 18 months. As you will see in the supporting representations, there are several comments made about the safety concerns in premises located within the Peterborough City Council authority. As the premises is based in Yaxley, it is the responsibility of the Huntingdonshire District Council Licensing Authority to ensure that the pattern of behaviour demonstrated by the previous breach of conditions and unlicensed activity does not escalate to a point where serious incidents are allowed to freely occur. I do believe that this premises actually has the potential to be a welcomed asset in the Yaxley community, which is evidenced by the sheer number of representations in support. You will have heard from the licensing officer today that that's 54 in total. But I believe that significant changes are needed to prevent an escalation. In conclusion, the evidence showing the continual unlicensed activity, the continual breach of licensing conditions, as well as the volume of complaints, demonstrates that a problem does exist at the Lancaster Lounge. I request that the committee today strongly consider my request to remove Mr. Ricciardi as the DPS, to restrict access to the external area to a more suitable time, to restrict live music being played in the external area, and to require SIA-approved door supervisors on Fridays and Saturdays. I remain available for any questions, and for clarity, if anyone would like to address me as William, as opposed to trying to pronounce my surname, please feel free to do so, or simply address me as the licensing officer. I won't be offended. Thank you.
Thank you, William. Firstly, do any members of the subcommittee have any questions for the applicant, William? No. Okay. Do any officers present, like the licensing officer or the council's legal representative, have any questions for the applicant? No, thank you. And does any responsible authority have any questions? Thank you. So, do any of those people who have made representations have any questions for the applicant? Now, this is for questions only. There will be an opportunity to make statements shortly. Thank you. No questions? Okay, thank you. I will now invite interested parties to address the subcommittee. Sorry. Yes.
Apologies. We're the premise license holder. So when you say interested parties, I don't respond. That's the so. I do apologise. I do have questions.
Yes. You are the interested party.
Thank you, Chair. To the sorry.
For clarity, we refer to you as the interested party, but you're actually, obviously, in your case, you're the person's premises license holder. So it's the terminology that we use, which is slightly confusing. Yeah, thank you.
It's fine. If I hear either, I'll put my hand up. Thank you. So I have a couple of questions, or a few questions, to the licensing officer, if I may. Officer, could I just clarify first? Has there been any underage sale to anyone, or any evidence of underage sale that you've, as the licensing authority, witnessed or been involved in?
No, and that will be why it's not referenced anywhere in my supporting evidence or statement.
Has there been any interview or any steps regarding drunkenness from the licensing authority?
Sorry, can you clarify what you're asking, please?
Well, has the licensing authority been investigated or seen or witnessed any patrons intoxicated, or had a PACE interview with the premises about intoxication?
Sorry, you're asking a lot of information, so let me just make sure I understand correctly. You're asking if I've investigated specific incidents of drunkenness. Have I PACE interviewed anyone for drunkenness? Is that correct?
No, I'll ask the question again. I'm trying to break it down for you.
We ensure that all questions go via the committee, so it should be to the committee, back to William, not directly
absolutely, yeah, and
Thank
that's
you.
my intention, Chair. So through you, so I want to ask a question about whether the licensing officer, as the licensing authority, is taking any investigation regarding drunkenness, intoxication, whether they've called the premise license holder in for any PACE interview or anything like that regarding drunkenness or intoxication.
Thank you, Chair. So in response to the question, we have received complaints of drunken behaviour in the premises, which has formed part of my detailed statement and submissions, and it has prompted visits to the premises to support them when we've received complaints about drunkenness. I have not invited the license holder in for a PACE interview. It has all been dealt with through a stepped approach via inspections, meetings, and the review today. Thank you.
And I asked the same question in relation to any crime or disorder. Has any crime or disorder been witnessed by the licensing authority, and whether they've taken any steps through a PACE interview or formal process, please?
Thank you, Chair. So my answer largely remains the same. I would also like to just expand on my answer and clarify that these inspections have been conducted when the premises is either closed or only just open. So I've not personally witnessed any of these incidents of crime and disorder or drunkenness. I have, however, received complaints and appropriately responded through inspections or meetings with the license holder. And I have not PACE interviewed him for any offences for that matter.
Thank you, Chair. In relation to the premise licence holder or the DPS, can I just be absolutely clear? There's been no open investigation, no PACE interview, no written warning regarding any findings of fact.
The premises license holder has previously been served with a Section 19 closure notice for unlicensed activity, and they've had several emails advising them of steps that they need to take.
Thank you. I'll just carry on, if I may, just a few more. So in relation to the Section 19 closure, just turn it up. I'm going to just... Thank you. So it's page 31, For you, Chair, I just want to ask a couple of questions about this, if I may. Can I firstly ask whether the officer, after serving the closure notice, whether any steps were taken to go to the magistrates to get a closure order, or was that as far as it went? So that's the first question.
Hi, Chair. In response to the first question, no, we didn't go to the magistrates' court as the premises was advised that they could apply for temporary event notices to cover the ongoing use. And they applied for several temporary event notices, which satisfied the fact that they were then doing it correctly. So no further action was taken, and we received a minor variation as advised.
And can I just clarify, it talks about off sales outside drinking area. Is that in relation to page 45, is the area that you're talking about where it says outside seating area, is that the area where you say that there were off sales?
Hi, Chair. As you'll have heard in the officer's report, there was a minor variation submitted to change the plan. At the time, the premises did not have the outdoor seating area shown on the plan, which is not part of the licensable premises, but this is the particular area where alcohol was being consumed without licensable permission.
So just to clarify, are you saying that the area that's shown outside seating area, that area wasn't shown, forget about the words for the moment, Chair, but that area was never shown as an outside area for the on the original plan, are you saying that, officer?
Yes, that is correct. That was an addition to the premises much after it opened. Part of the work, as you'll see in my statement, and some of the submissions are that there was an error with the plan. They put in a new plan. They increased the seating area. They showed it on the plan, but it is not licensable, hence why it's not delineated with the red line. But yes, this is an updated plan as per the minor variation.
So just to clarify, because I wasn't sure of the answer, Maybe the officer can just clarify. It was shown on the plan, but wasn't shown as a drinking area. Is that what he's saying?
Hi, Chair. To clarify, the current plan that we're looking at on the pack that says outdoor seating area was never shown on previous plans.
But was the original plan on the application? Do we have that in the pack at all? Or do you have that showing? You're saying that there's no external area being shown at all on that plan.
The original plan that was part of the application did not have the outdoor seating area shown on it. The plan that is part of the license, that is part of today's pack, was a new plan submitted as part of the minor variation as detailed in the report.
Okay, thank you for answering that. I'll deal with that later. In relation to the alleged breaches of conditions, it's fair to say that there's been no action taken by the licensing authority regarding warning, caution or prosecution. Is that right?
Just to remind, okay, that's a question. Yeah, just remind we are on questions at this point. Thank you.
Thank you, Chair. So to continue on with the line of questioning and answering, yes, no formal warnings or no, sorry, I can't even remember what he said now. He's asked so many things. But the answer is no, basically.
Well, let me be clear because it is important. And as it's an enforcement officer, I thought I could mention all three, but I'll do it separately. So no warning, no caution, no prosecution. Is that my understanding?
Your understanding is correct. There have been formal words of advice given, and there have been written instructions in email about what can and cannot be occurring. We have not taken further enforcement action because we have been taking a stepped approach where words of advice were deemed sufficient. After the words of advice failed to be sufficient, the next stage in enforcement action was to call an application of review, which you'll note is not calling for revocation of the license, is for calling for changes. So no formal prosecution or cautions or any other type of enforcement action has occurred to this date.
Okay.
One moment, Chair. I just want to double check. I've asked all the questions I wish to. And that's all I need to ask at this moment. Thank you.
Thank you very much. Moving on then. So I'm now going to invite interested parties, including the premises licence holder.
Chair, I think the police have and the council, the Environment Health have to go first.
Apologies.
That's all right.
Okay. So, please, do you have any questions to the applicant? Okay.
I've got no questions to the applicant. No.
It's not questions, this is their...
It's very confusing when you're switching the other way round. It's when you do a review. I understand.
Apologies, right, my misunderstanding. So, may I invite the police representative to make their own representation? Thank you.
Certainly, Chair. Thank you. Thank you for your time today. I've got nothing further to add other than what I've put in my statements already. I think William's spoken quite elegantly and put it forward to yourselves. He's not looked for revocation. Police haven't suggested revocation at this time either. During the time that I've met Mr. Vicardi since he's opened, I can confirm William has been supportive and given advice. I've been present on a couple of those occasions. I've given advice as well, which I'm sure the owner would agree with, that we've given relevant advice to him. I've made reference to a couple of incidents that have been reported to police. I think far more has probably been reported to the council than they have to police, according to our records. And I can confirm that on the last inspection I did with William, we did the drug wipes, which I believe Mr. Dadds might have some questions about. But that's it for me.
Thank you. Do any members have the subcommittee have any questions for the police representative? Do any officers present, licensing or the legal representative, have any questions for the police representative? Does any responsible authority have any questions? That's yourself, actually, isn't it? So there's nobody else. Yeah. Do any of the people who have made representations have any questions for the police representative?
Thank you, Chair. Good afternoon, Officer. I have a few questions through the Chair, if I may. Could you just confirm for me that in relation to crime and disorder, certainly this year, 2025, that there's been nothing of note at all at the premises?
That's actually correct. We've had a report in August. It's in the second statement I provided. On the 7th of August, there was a report of threats being made to persons within the premises.
Is that the only thing?
That's the only thing this year.
Yeah. So what I would like to ask, if possible, through you, Chair, is that has the police attended at all the premises in relation to crime disorder in 2025, please?
Okay. There was a second report, if you let me finish, of drug use in the premises. That was reported as intelligence on the 28th of the 8th. In relation to police attending the premises, no, we haven't attended any incidents. In relation to the threats, that was reported after the fact, and that case is actually currently ongoing. And I believe they've probably approached the premises for CCTV already.
Yes, Chair, and we need to be careful. If there are any live investigations, the officer should tell us so that we don't step into a contempt of court in relation if there's a live investigation. So one has to be very careful about what we say about that, if that is the case. In relation to the intelligence that you said that you received about drug taking or use, can you give me the grade, please? The grade of the intelligence.
It came in as a report of an incident, and it's been listed as an incident to my knowledge.
Sorry, no, I asked for the grading of the intelligence,
Yes,
please.
I've not got it on as a intelligence. It came in as an incident report.
But you gave evidence just a minute ago saying that you'd received intelligence. So would you like to correct the record that it's
Yes.
not an intelligence, it's a report?
Okay, it came on as a report of an incident of drugs being taken on the premises, which you could take as intelligence to say drugs being used on the premises.
Wow, Chair. So was there any investigation about that?
Hence, on my last visit, we took some drug wipes and we wiped down the areas within the premises, one of which being the disabled toilets, which is where the incident said the drugs has been used, and that came back as positive. And if you look in my report, when we wiped down the high chair table, it came back as positive in there, and on a toilet lid as well.
Yes, I'll come back to those in a minute, Officer. But in relation to if there's a report or a complaint of drug use, has that been given a crime reference number, please? And what is that crime reference number?
No, there's no crime reference number because we haven't stopped anybody. We haven't got a crime reference number, no.
So, Chair, for you, so if there's no crime reference number, there can be no criminal investigation unless the officer is suggesting that there's a criminal investigation without a crime number, which would be against PACE, a number of pieces of safeguarding legislation. So someone's made a complaint, it's not been recorded. I understand, Officer, you're saying it's not been recorded as a criminal complaint. So therefore, it's not referenced as a crime at the moment. It just falls, and it's just fallen as someone's giving you some intelligence, and there's no formal investigation about it because there's no crime reference number. If you are formally investigating it, you have to have a crime reference number. That's right, isn't it? I'm not cross-examining, but I'm just clarifying the point.
Is there a question, Chair, for me?
I think the question is clear and the public can see it. If you are alleging that someone's made a complaint or a call to the police about drug use in a disabled toilet within this licensed premises, I'm asking, is there a crime reference number? You said there isn't. I'm saying, well, if there is no crime reference number, there can be no investigation. That's right, isn't it?
There is no investigation into the use of drugs at the premises at the moment, no. Because we do not know who the person was that was potentially taking the drugs. We were just informed that drug use is occurring in the premises.
So just to interject that, so that standard procedure is that you find illegal substances at the premises, but you can't pinpoint the perpetrator, then you wouldn't record a crime reference number. Is that standard practice?
Yes, we wouldn't report a crime because we don't know who the offenders are. We don't know.
Chair, thank you for your question. Would you allow me to continue? Would you mind?
Yeah, but if this, to be fair, if this says it's standard legal practice, then it is, we can't argue with that.
So there may be like a street robbery that you've just been, say, stolen a phone off, snatched out of your hand. You may not know the person that snatched out your hand. The police will record it as a crime. It is incorrect, and the officer can correct his statement if you like. It's incorrect to say that no crime will be recorded unless you know the perpetrator. That's got to be wrong as a matter of process. So that's why I sort of said, could I continue? Because I think that's wrong. I'm asking the officer. He says there's been no criminal investigation. And I'll make submissions. But, officer, did you go in and ask to see the CCTV of the toilet area, for example, on the reported date when this alleged activity was occurring?
Chair, if it was a crime, it would be a possession of a class of substance. No one, when we entered, there was no one present, as it was just us and the DPS. Therefore, we were just checking for drugs in the premises. So no officers attended on the evening, no one has stopped. We have no one in possession of drugs.
So moving on with other questions now, if I may, Chair. So in relation to the police actions, I take it the police have given no cautions, warnings, or any, or even considering a prosecution of any matters arising of 2025. That's right, isn't it?
There's a live investigation, as you rightly said, which I cannot talk about at the moment. Other than that, we have no prosecutions against the premises.
And no warnings or cautions,
no
that's
warnings.
Right. Thank you. In relation to the wipes that you've used, I'm going to ask some questions now about the wipes and testing at the premises. Do you accept the principle that actually it's good practice to work with licensed premises if there is intelligence regarding drug use, and really that should be worked with the premises? It shouldn't be used as a negative. It should be seen as a positive to work together.
We do work together. I went in after the information came through, hence the drug testing to try and identify where the drugs are used, and also to indicate whether or not it was a false reporting, whether or not there is indication of drugs on the premises, and there was in numerous locations. a consultant that the DPS, the owner, had in at the time, walked with me around so he could see what was happening and where these places were. So it wasn't just me saying to the owner where the places were. But yes, it is good to work with them, and that was my intention on that day.
And so, what have you done since then? Have you made a plan of going back, making sure it's all clean, going back, then after it's clean to see whether there's a repeat? Have you even considered going back with an ion track itomizer to see what the readings are to make sure it's not cross-contamination?
In our department, we did not possess an ion track itomizer, whatever it's called. We do not have one in our department. In relation to going back and testing, I will do when I have a chance, but I have other premises to check. Myself and William were discussing that earlier about going back and seeing yourselves today. Not today, on another occasion.
But officer, do you accept that the wipes are only possibly an indicator of a trace? They don't say whether there is a direct use or contact on the surface. It is a trace, and a trace could be through cross-contamination, whether that is someone's used a drug away from the premises or have it on their hands. It used to be with currency, where people cross-contamination, touches surfaces, and that will give a positive read. And then you have to go back and do an ion track to see whether there's a direct contact with that surface, not a cross-contamination. I mean, are you an expert in this area? Are you able actually professionally to give professional opinion and advice and before a committee regarding the validity of these swabs, what the readings were, whether there's a direct contact with the surface with a drug or whether it is cross-contamination?
Okay, the wipes I use are very much like a wet wipe. I think most people can use a wet wipe in this room. You wipe the top of the surface, it indicates blue if there's drugs there, and it shows a trace of the drugs. It shows potentially that someone's been in the premises, used or left drugs behind. It wasn't like it was a one-off, it was in numerous places. I'm not here to determine how the drug got into the premises. I'm here just to indicate that there was a trace of drugs. I'm not a drug expert. I never proclaimed to be a drug expert. I was purely there to show the operator that potentially those drugs have been present in his premises and used in certain location. And the main area we went to was in the disabled toilet, was what we was told, where the drugs were potentially being used by patrons attending the premises. That was all it was for. So that he could then look at it and go, do I need to do more in my premises to prevent drugs from coming into it? We discussed this at the last meeting, and then he's looking at putting in a search plan following that, which is what it's about. It's me indicating you may have an issue, you may have persons come into the premises, and they may be using drugs within your premises.
With respect, Mr. Dadds, I think we've exhausted this point. I've
Can
heard,
I ask two more questions on it?
on other
Chair?
points you may, certainly, but I think we're satisfied that the police have found drugs on the premises. You're questioning whether the drugs might have, some come through indirectly. I mean, you could ask all kinds of questions about things not actually being as they appear to be.
There's been no drugs found on the premises, sir. I mean, and I want to make it absolutely clear for your correction that there's no drugs found on the premises. What's been undertaken, as I understand it, is that a wipe has been used to check a surface, which has given an indication of a trace. And I'd like to ask two more questions on that, and I'll wrap it up. But then,
Okay, briefly, if you would.
Thank you. Yes, I will. In relation to the indicator, the trace, do you accept that could just be through cross-contamination, not direct use, officer?
I'm not an expert. I'm unable to confirm or deny that.
And the last question is just to clarify that you've said it may not indicate of a direct use. Is that right?
As I said quite a few times now, it just indicates a trace. How it got there, I don't know. I wasn't present in the toilet. Whoever put it there, they did it however they did it, or they left it however they did. I'm not an expert in that. All I can tell you is there's a trace of a drug substance on those surfaces.
Chair, I have no more questions. They were my questions. Thank you.
Thank you. Now, next, may I call on the Environmental Health Officer to address the subcommittee. Thank you.
Thank you. So I think the written representation that we submitted largely speaks for itself. Since the grant of the licence, we've received numerous complaints about antisocial behaviour and noise nuisance from the premises, which we've been investigating in conjunction with licensing colleagues. Most of the complaints have been primarily linked to the use of the external areas, the playing of amplified music in this area, and more recently the use of fireworks at the premises. So we've asked on here, not, as Paul has said, not to revoke the licence, but just for some additional conditions to be put on to control these, and I'm happy to take any questions.
Thank you. Do members of the subcommittee have any questions for Kate? No. Thank you. Do any officers present, licensing or legal representative, have questions for Kate? Any other responsible authority have questions for Kate? No. Thank you. Do any of the people who have made representations have questions, that's to say yourselves, or have questions for the Environmental Health Officer? Thank you, Mr. Dadds.
Thank you, Chair. Thank you, Officer. So good afternoon. Could you just confirm that there's been no noise abatement notice issued in relation to the premises?
Yes, I can confirm there hasn't been a noise abatement notice issued.
Have you been to the premises June, July, August, and September to witness any noise breakout?
I haven't been to the premises in person, and the team hasn't been to the premises to witness anything, no.
And can confirm in relation to the complaints that you have received, they haven't been cooperated by an officer of the local authority, that's right?
So the complaints we have received are from local residents, and they are complaints that we're investigating. We haven't got evidence from, I guess you're asking, from noise recording equipment or something like that, and that's purely because we're not at the stage, and I think this process has potentially paused some of the complaints, so we haven't got to that stage so far.
Thank you. I've just got a couple more questions, if I may, for you, Chair. So I've got it in June. There was one complaint. Is that right?
So in June, we received a complaint from a new complainant. We record that as one complaint on our system, but since that time...
No, I'm just asking for June at the moment. I'm going to go to the other months.
Yeah,
I'm breaking
so
it
since
down.
that time, that person has contacted us on more than one occasion.
Yeah, so, but in June, there's one complaint in the month of June, one complaint in the month of July for the summer. Yes?
So these are, this is from your list, isn't it? This is from my list. Yeah.
Well, is this, sorry, can I just clarify, from environmental health's point of view,
Yep.
you record any complaints from the public, is that right?
Sorry, can you explain?
You record, environmental health record any complaints that you've received from the public, is that right?
Yes, we receive, complaints from members of the public.
So I want you to check your records, not the licensing authority records, your records. I understand it is one complaint in June, one complaint in July on your records. Is that right?
So the information I've got here is the dates the complainants initially contacted us. I would have to go away and get, if you want, every single line, but I don't think we're obliged to give you that information at this stage. I'd have to seek.
But I've been given the information here today. So I've got it as one complaint in June, one complaint in July, 4 complaints in August, 2 complaints in September. Now, are they from your records or is that from someone else?
Sorry, Mr. Dadds. Perhaps if I can help here. You asked me for a list of all the complaints. You didn't ask me to separate them out between EH and licensing. I've given you all the complaints and all the dates that you asked for, but they've not been separated out between EH and licensing, okay?
That's fine. Thank you very much. That sort of clarified where I am because I'm thinking these are all from environmental health. They're not. So from environmental health complaints, you're not able to tell me how many. So we know the maximum is 1 in June, July, 4 in August, 2 in September. Out of those 8 complaints from June, July, August, September, and we're now in October, how many of those relate to environmental health? Are you able to tell me, please?
I'm not able to give you specific dates at this moment in time, but that would be.
I'm happy to pause for a minute, Chair,
Yeah,
because that might
if
be
you can.
relevant.
Yeah, if you can do that. I will. Thank you. Yep. So from the information on our system here, we received 2 complaints in July. Sorry, let me start. I can't read my own writing now. 2 complaints in June, 1 in July, 4 in August, and 1 in September.
Thank you, Chair. I don't have any more questions for the officer. I'll wait for my submissions.
Thank you.
Thank you.
Can I just give the other interested parties, the 3 people at the back of the room, the opportunity to ask questions of the responsible officers if you have any questions at all? Okay, thank you. Okay, so now the point where I invite interested parties to address the subcommittee for no more than 20 minutes in total. That's across the people who are interested parties. May I invite you, the representations must be relevant to the 4 licensing objectives. And Mr. Aylick, can I ask you to speak first? Thank you.
Thank you. So I've made a submission and I don't intend to read that out. I just want to emphasise a few points. So I've lived next door for 35 years, opposite the Three Horseshoes pub for 35 years. I've never ever made a single complaint. Nothing. I have no problems with licensed premises until the Lancaster Lounge came on the scene. At the start, I was very helpful. I was very supportive. I let them do construction work from my property. I helped them reporting when there was people in the building vandalising it. And made whatever contact I could. And at the time, the licence holder told me it was going to be a high-class piano bar and small plates restaurant, specifically designed not to have the scum in, as he called them, from the Three Horseshoes. So that was his vision, that it was going to be a high-class bar. I quite realised that the owner has never ever told me the truth. Any question I've ever asked, any comment he's ever made, it's always been not fulfilled. He seems to be a complete fantasist. Mr. Dadds, I've had to listen to your... now you can listen to me.
Yeah, but please...
Additionally, he does not seem to have any regard...
With respect, Mr. Elliott, please don't do any character assassinations. Thank you. It's not what this meeting's for.
All right, okay. Additionally, he doesn't seem to have any respect for social norms. For example, the car parking space was always outside on double yellow lines. He parked his car when he was able to drive there for much of the time. And that is just not normal. We live next door to a fire station, and the double yellow lines there are for public safety. His MO generally seems to be ask for forgiveness rather than permission. And I know I can't mention the planning applications here, but it is true that the original planning application did not allow for the outdoor area, and it said it would be forever and in perpetuity for a car park. However, the main point that I want to raise is the impact on family life. I'm a grandfather. I have grandchildren. They are of a young age. I cannot believe that when I bring them back to my house, I've got people simulating sex acts with sex dolls outside the premises. I cannot believe the foul language that I have to put up with on a daily basis. When people come to their car park, we can have entire conversations based solely on the use of expletives. I've had vomiting, urination around the property, and I did explain this to the owner several times. He did once clean it up, and he sent me a video of himself doing that, which I appreciate. But mostly he thought it was just something that he could carry on with and was just lads being lads. Told me he wanted to be part of the community, but what in actual fact he wants is an Ibiza club, and it's not suitable for a village conservation area, and I'd ask the committee to take that into account, please. Thank you.
Thank you, Mr. Aylett. So, do members of the subcommittee have any questions for Mr. Aylett? No. Do any officers present have any questions for Mr. Aylett? William, do you have any questions for him? No, thank you. And responsible authorities, no questions? Thank you. Do any of the other interested parties, the licence holder or others, have any questions for Mr. Aylett?
I'll leave it for submissions.
Okay, thank you. Moving on then, I invite now Ms. Clark to speak next. Thank you.
Thank you. My husband and I live about 50 metres away from the Lancaster Lounge. We've been going in there ever since it opened. In fact, we went to the Lancaster Club, as it was before the Rapper Club. I was the treasurer there. We absolutely love going to the Lancaster Lounge. We have never, ever witnessed any antisocial behaviour. We're both pensioners, and I, as a lady of 70 next year, would not worry about going in there on my own. I feel very, very safe. It's a lovely place to go. We often take our grandchildren in there, and there's absolutely no problems. I would just say that we've just never witnessed any of the things that you've been saying. Never. We've had beer glasses thrown in our garden, but they've been coming from people coming out of the Three Horseshoes pub. We've had fighting going on outside our house, but again, that's come from the pub. We haven't complained. It's a pub. These things happen. But the Lancaster Lounge is just an asset to Yaxley. It's a lovely place to go, and I wouldn't hesitate in recommending it to anybody. And that's how we feel.
Thank you, Ms. Clark. Do any members of the subcommittee have questions for Ms. Clark? Councillor Bittell.
As a pensioner, how can you afford to go in there every night?
My question would be just how late in the evening, and what's the latest time that you frequent the lounge in the evenings?
We often go in there early. We go in there sort of like 6, 7 o'clock, but we have been in there at closing time as well. We went to the New Year's Eve dinner and dance that was held there last year, which was absolutely fantastic. We've been at all different times of the day, and honestly, we've never noticed anything untoward.
Any questions from members? No? Okay. Do any officers present, licensing or the legal representative, have questions for Ms Clark? Does the applicant or his representative have any questions for Ms Clark? The responsible authorities? No. Okay. Do any of the other interested parties have any questions for Ms Clark? Again, questions only.
No, I normally leave it just to submissions. I don't normally ask the public questions.
Okay. Mr Ayler, do you have any questions for Ms Clark? Okay. Moving on then to Mr Freeman. Would you like to make your submission?
Thank you, Mr. Chairman. Just referencing a comment that the licensing officer, William, made, if I may call you William, rather than attempt your second name. You mentioned that it has enormous potential to be an asset. I'm not sure if that's the exact word, but to the village. It has already become a massive asset. It provides local employment and it contributes to the economy, of course. Notably, just of late, it is I'm not sure if everybody's aware, it's just achieved among the top 10% of bars and restaurants worldwide in 2025. Now, that is an accolade that very few can claim, if any, locally. So it doesn't get that kind of recognition without it being something special. I'm a COO for a national charity, and since discovering the Lancaster Lounge, I've held business meetings there, obviously not on a Saturday night, but I've had business meetings there with clients and staff, and we are actually having our Christmas bash there in December with all of the head office staff and some local volunteers. Now, we wouldn't do that if the venue was as it is being made out to be. So I consider it a very, very safe place to go. My wife and I celebrated her 60th birthday there in January of this year, and we were the last to leave because we didn't take over the whole venue, but we took over a part of it, and there was no evidence of any trouble or any arguments, any people threatening anybody else. And it's the only place that my wife will actually go out with me in Yaxley to socialise. That's all I have to say, Mr. Chairman. Thank you.
Thank you, Mr Freeman. Any members of the public have, members of the subcommittee have questions for Mr Freeman? No. Any officers present have any questions for him? No. Does the applicant or his representative have any questions? No. And the responsible authorities? No. Okay. Do any of the other interested parties have any questions for Mr Freeman? No. Okay, thank you. So that brings us to Mr Dadds and Mr Ricciardi. To your submission, please. Will Mr Ricciardi be speaking as well?
No, I'll speak on his behalf if I may. Obviously, we'll attempt to answer any questions you may have. I will attempt to keep my submissions to the relevant points and hopefully within 20 minutes or less. I've done a speaking note, which obviously I know that you'll have a copy when you retire, but I'll cover some of the salient points. But I might just speak slightly out of turn insofar as, can I say this, is that there's been concession made by the applicant, the licensing authority for review, that says, and obviously it's your discretion, your decision, of they want the DPS removed, the external area to be reduced, something about live music outside, and SIA door supervisor. That's in effect the nub of what they're asking for. And I'm going to, during the next 20 minutes, set out why that none of those steps are required in my submission. So I'll start first by saying this is obviously the first review. I would normally have expected in my submission a more graduated approach to enforcement. The officer's indicated that he has taken those steps, a graduated approach, i.e. words of advice and then straight to review. There's a huge gap. It's words of advice, then it's written warnings, then it's possibly a PACE interview or an interview, and it's a firm instruction that if you don't change a course of direction, normally they call them action plans, if you don't achieve an action plan, then we'll take you to review. It's not words of advice and straight review. There's a huge gap. So there's been no graduated approach to enforcement. They're not required under the Licensing Act to do that. However, the Regulator's Compliance Code, and it used to be the Enforcement Concord Act, would say always when you have power, you should exercise it in an appropriate way and a stepped approach. I think it was Hamlet that said it's great to have the strength of the giant, but tyranous to use it as such. And I think it is about a graduated approach. Any determination must be evidence-based as being appropriate to promote the licensing objectives and be proportionate to which it's seeking to achieve. Evidence-based. Members, in relation to the police, there's only been one matter arising this year in relation to alleged threat that's under investigation. There's no conclusion. That's it. There's been a complaint or intelligence regarding alleged use of drugs within the premises, but there's been no criminal investigation open or an investigation open. I mean, that's as a matter of fact. The officer's conceded that he's not an expert, can't give you advice. And I would caution everyone to be very careful about the wipes, because they are merely an indication, a trace that there's been some contact with a substance. Now, obviously, until you do a proper swab analysis, you don't know what that is, and you do not know the level of what it is. And one has to be very cautious and careful regarding that. And ordinarily, that type of information is not shared with the public, and certainly not at first instance, because it would normally be, look, we've done these wipes, let's give it a good clean, let's come back. If there's another indication, you might say, well, I've got to go and get an iron trap machine here. We might have more of an issue arising. But I'm sure you will know, members, that in society, drugs are used by different people. That doesn't mean they're being used on this premises. And that if they've touched drugs and they go into the toilet area, or they touch even the child seat, they could leave a trace, because some of these substances stay on a person's body and can be left on a surface, and it doesn't get taken away until it's wiped. So it can remain there for some significant time. This is why one has to be very careful about that evidence. So from the police point of view, the police have taken no further action in the last year or any other matters. So in relation to SIA door staff, there's no intoxication, no drunkenness, no fighting, nothing that would warrant at this location that's got a license to 11 o'clock, or everyone out by 11:30 or whatever, would warrant having to pay out something like nearly £15,000 a year indoor security staff every Friday and Saturday. So one has to be very careful about just banding about, well, let's just have a couple of doormen. Well, firstly, you have to show that it's justified, proportionate and necessary, and you have to weigh that against the cost that would cause this licensed premises. And given that there has been no matters arising, then clearly only one matter this year, it can't be necessary. I do hesitate to say that this is an unusual license, and I have said to the premise licence holder, he needs to make an application to vary. Because ordinarily, a premises like this would be licensed much later, and possibly to 12 o'clock. And normally, the people being on the premises is not a licensed activity. You would have drinking up time. So, for example, it says hours open to 11 o'clock. Well, people being on the premises, as long as they're not doing licensed activity, is not a breach of the Licensing Act. The Licensing Act, Section 136, is very clear that it's only an offence if you're undertaking a licensable activity other than in accordance with a licence. And if people remain on the premises consuming alcohol, they're entitled to do so because that's not a licensable activity. Normally, they'd be drinking up time. So I'm a bit concerned about the restrictive nature of that. But as we have it today, there would be no offence. In relation to the licensing authority, they have not witnessed and not even been present during the late night operation of the premises. And you would find that quite alarming. If it's such a condition that you've got to go and take a review, you've not even been there on a Friday and Saturday night and had a look for yourself. Nor has the environmental health officer or her team been there present on a Friday or Saturday night, or when there's been any complaint. So no officer of the council's been present. We do know that the gentleman next door has raised a number of objections. The ones about planning we can't get into, but there is clearly a disagreement between the two parties about planning, about use of land, which fall outside of the Licensing Act. Now, obviously, the licensing authority are not seized with judging criminality. So the licensing officer has suggested, for example, that there are breaches of the license, and that I assume that what he's saying is that there's a crime. But obviously, that's not for you to establish here. Sorry, Councillor, have I said something that you disagree with that I need to cover? All right, okay, sorry. So the reason why I say that is because the Licensing Act is about preventing crime disorder, but normally on a review, you have to look at the causes of concern that have arisen relating to the licensing objectives. So if there is no crime and no disorder, then the crime disorder objective is not undermined. So the reality of it is it's looking backwards. This isn't looking, we look back and we look forward on a review. But looking back, if the officer is suggesting that there is a crime occurring on the premises, which I don't know whether he is or he isn't, if he is, then he's not entitled to do that until it's gone to the court, because our client is entitled to the right to innocent until proven guilty. So, for example, there is a suggestion that there is a crime being committed by cooking a pizza after 11 o'clock. Now, that pizza was not for sale and for staff. So what the licensing officer is suggesting is that there has been an offence under the Licensing Act. But I can tell you, members, there is no offence under the Licensing Act in relation to that matter. In relation to the consumption of alcohol in the garden, that's not a licensable activity and would not be an offence under the Licensing Act. And the reason why I'm saying this is that if, for example, there is a suggestion that there are offences or breaches of licence, which is an alleged crime. That's what the officer said. He said originally that he's not really here about the complaints, he's here about the breaches of licence. Well, if there's an allegation of a breach of licence, my client is entitled to, one, to understand exactly what is being put, entitled to reply, and entitled to go to the court and say, actually, that is not correct. So, for example, the Section 19 closure order, it is my opinion that the garden area of a licensed premises is not on off sale. And there's plenty of case law in relation to that. And we know that there were a number of provisions under the COVID regulations that allowed for off sale, but actually this is within the curtilage of the same premises, and there could be a legal argument whether that is an off-sale or not. But that's not for here. That would be for a court to look at if it was in the public interest to even pursue. And obviously that was regulated or regularised if it was needing to be done so by a minor variation which was dealt with. So it shows that the premise licence holder is receptive to receiving advice and has taken steps to make a minor variation to address the concerns raised by the licensing officer. In relation to any, my submission is quite clear that if the officer believes that there is a crime or a breach, then that should wait for the criminal proceedings to follow through, unless, and this is the unless, the guidance is quite clear that you don't have to wait for criminal charges to be made before you can determine whether there's been an undermining of the licensing objectives. But I don't believe that the officer hasn't demonstrated this in his evidence, that he's never been there to witness undermining the licensing objectives. He hasn't been able to corroborate anyone else's complaint of undermining the licensing objectives. And so, for example, the cooking of the pizza or the allegedly serving alcohol 2 minutes, 3 minutes or 4 minutes or 6 minutes after 11, whether any of those alleged breaches undermined the licensing objectives, because it's not being suggested that those individuals who consumed or bought alcohol in any way went on to commit any undermining the licensing objectives. And this is my point. He makes great play of that by saying, well, he was standing nearby. We make it quite clear that our client would have a defence under Section 136 because he's given clear instructions to staff not to serve after 11. He relies on the till receipt time. We don't know whether that time is correct or not. But in any event, we would say that he was standing there and would not have knowingly allowed a sale after that time. But obviously that's for a member of staff to make sure that with the time that they don't serve after, and he would be entitled to that defence. So the suggestion that he has committed a crime is not the right place here, and we mustn't determine that. But I don't believe the officer has suggested that anyone that was served 2 minutes after 11 or 3 minutes or 4 minutes, any of those went on to commit any crime or undermine the licensing objectives. And this is the point. We're looking at the licensing objectives. The committee mustn't make any findings of fact in relation to alleged crime, and they're not entitled to, in effect, go and start to fact find on those matters. If it's an alleged that there's a breach, that should be the proper place for that is a criminal court, not here. And that's, I think, the danger, members. I know that I'm probably skating on thin ice by arguing these points, but I've got to argue them robustly for my client, because to go from, in effect, words of advice and coming here, it's like as if here is where we're going to get a punishment. And this is not about punishment. The punishment, if there is a punishment, that's at the magistrate's court. What we're here for today is saying, right, has there been an undermining of licensing objectives in the past? And will there be an undermining of licensing objectives going forward? And you've heard already from residents that live nearby or frequent the premises that the premises is a fine establishment, looks after its customers, not have any concerns at all, and that as I think received over 60 odd representations in support, or 54, sorry, in support, and I think 64 were rejected. But nevertheless, this is, and with a petition of I think 90. So you can see that this is a premises that is loved by the community, supported by the community, and is an asset of the community. Councillors, we've been here many times, I'm sure, and you would have been here, that the members of the public would not speak up for a premises if they felt that it was undermining the licensing objectives in their local community. And I think that is something which I'd ask you to treat with great weight, particularly when there's been no licensing officer, no police officer, no environmental health officer that's ever witnessed a matter arising at that premises. Not once. Now, the statutory guidance says that you have to look at the cause or causes of concern and only do what is necessary and proportionate to address that concern. Now, in relation to the premises, we have taken advice from the police service, and we've gone through a sort of a system of accreditation through Licensing Savvy. That has not concluded yet, but staff have been trained. There's been proper analysis of all our procedures, and we've gone through that exercise for a number of weeks to make sure that everyone is satisfied with what we are doing. So, and I understand that we're due to be signed off with that, but they won't sign us off until this review is concluded. So we've in effect going to get the accreditation for Licensing Savvy, which is no mean feat. It's quite a task. I can also say that the committee, the premises is committed to signing up to Licensing Connect, which is a digital compliance tool that has the refusal register, instant book, training for licensing, waive. So it has everything that's needed, notwithstanding that's already been given through Licensing Savvy, as I understand it. Then in relation to my paragraph 7, you look back at what is alleged to be the problem in order to look forward to saying what will you do going forward. And it's quite clear that one has to be very careful about that being proportionate. So, for example, I've said about the door supervisors, that's not needed. There's no punch-ups. There's no issues going on where we need door supervisors. And the cost of having door supervisors is tremendous. In relation to the live music, the premises before, when it was the club, it used to have live bands out in the garden often. The issue with the bank holiday weekend, and the complaints came in about 9 or 9:30 with a number of fireworks. We've understood that, and we've learnt by that, and we won't be doing that again. But in relation to that, that was a bank holiday weekend. Community were there. They were celebrating the bank holiday weekend. It was fine weather, and people do want to go out and go somewhere and have fun. Obviously, you've got to be considerate to your neighbours, and the premise licence holder knows that there were a number of complaints about that event. So he has said, well, I won't do that event again. But that event, in any event, is deregulated. So they could carry on and place that event without the need for a licence. And the off-sales, as I say, is consumption. So there isn't a need for a risk assessment for that event because it's deregulated. So in other words, you can run that event, conditions don't apply because it's deregulated. It's the provision of regulated entertainment, it's under 200. It's between 8 and 11. So therefore, actually, it can take place without the need for a licence, the live music. And I'm sure that your legal advisor will concur. But notwithstanding that, going forward...
One more minute, please. Thank you.
Going forward, we are not going to be dealing with that type of event. I'd ask you to look at the issue regarding the external area. We obviously do want to use that area, and as there's been no cooperative or any support from anyone else other than predominantly our neighbour complaining, we say that that's not necessary. I know that they don't want us to use that area, but it is our area and it is part of a licensed premises, and we do regulate it, we do manage it, and we are alive to the fact that we have neighbours and we do supervise it. And we have been monitoring it with sound, and we believe that there is no breakout of noise that would disturb the neighbour because we have buildings between us, And also we do monitor it to make sure it's not causing anyone a nuisance. We have offered mediation. We've offered to do sound monitoring in their premises through an independent assessor. And I understand, I think the council's even offered, and that has been refused. So, but I have made a note, and I know your legal advisor will comment on it, but I have made a note that if there is a complaint between Nextdoor and us, and that seems to be the main driver, that would be a private nuisance, not a public nuisance under the Licensing Act. And we are trying to do all we can to appease our neighbour, but if they don't want us there, we can't do anything about that. But I'd ask you that there isn't sufficient evidence before you, independent, to say whether actually we're causing any public nuisance in relation to the use of the rear area. I'd ask you to read the rest of my note. I will just finish on the last salient points, if I may, Chair. You have to obviously take into account the submissions placed before it. So far as establish the cause or causes of concern based on that evidence. There should be no determination of legal culpability, assigning blame or seeking punishment of anyone. You should be focusing on the future, and we've set out how we're going to deal with those matters, and that each application should be on its own merits. And we say that with the steps that we've taken during the review process, that should assure you that, in essence, that the licensing objectives will be promoted going forward. Thank you.
Thank you, Mr. Dadds. Committee members, do you have any questions for Mr. Dadds?
Yes. I wanted to ask, our officer at no point mentioned crime, but you've mentioned it at least, I think, 8 to 10 times. Why did you feel the need to do that? We're not suggesting there's been a crime. The officer is suggesting that there's been a breach of the licensing regulations. So why did you bring up the word crime?
Thank you for asking that question. The reason I've brought it up, and I've written it in advance, is because where the officer says alleged breach, with that means alleged crime, but it's the same. So alleged breach would be an offence under the Licensing Act under section 136. And under 136 says that if you carry on a licensable activity other than in accordance with a licence, it's a criminal offence. So he is suggesting that we have committed a crime, and that's why I've mentioned it, Councillor. Thank you.
Thank you. Any questions from members? No, thank you. Just curiously, when Mr. Ricciardi took over from Mr. Baker, what was the... Sorry, when Mr. Ricciardi took over from Mr. Baker, what were the premises under Mr. Baker's management? How were they different from since? Just for my clarification.
So there was the question around the garden use with the section 19. So we decided to remove him from the licence and put, as you know now, the director of the company on as the DPS. So we thought that was appropriate. There are no relevant matters or convictions or anything that would exclude him. In fact, he's been working with Licensing Savvy, working with the officers, doing a number of things. He will be the first to accept that he's learning on his feet, but he is providing a good customer service, a fine establishment. He's trying to work the licensing officers, and I think he is working the licensing officers. He wants to make sure that everyone is happy. He's even reached out with a neighbour with mediation, and likewise. So,
with respect, my question was about Mr. Baker and what were the circumstances for his departure.
Yeah, well, it was because moving on and him taking over. So that's it, really.
Thank you. Do any officers present have any questions for Mr. Dadds or Mr. Jardy? No. Thank you.
I just have a quick question. I just want you to take me through the deregulation, please. So you say that the event that took place over the bank holiday weekend could have been held completely deregulated. How are we, can you just take me through that, just so that I can make a note of it?
Yes, as based on the information present before me, that's a lawyer's answer, is that in relation to the provision of regulated entertainment, it was outside, and that outside, because it was between 8 and 2300 hours, and it was less than 200 persons, it's deregulated. The consumption of alcohol is obviously is not a licensed activity, but obviously the sale of alcohol within is, and obviously them taking it to that area for consumption. So in essence, you didn't need a 10. The regulated entertainment is outside of that. But notwithstanding that, we've recognised that some neighbours did not want to be disturbed at that bank holiday weekend. So just to answer that is that we've recognised that, and we won't do that again to that extent. And in any event, we will do it through consultation if we were thinking of doing an event and engaging. So it was really August bank holiday during the summer, and thought that there would be an outside event joined by the community, and obviously some of the community didn't like that, but it was one event. It's not a reoccurrence. Thank you.
Thank you. Just moving on then to the applicant. Does the applicant, which representative, has any questions for the premises licence holder?
Yes, Chair. I just draw some general observations from the submissions made. And there was an allegation that graduated approach, as detailed in the Regulators Code, not required by the 182 guidance, but standard regulatory practice, wasn't taken in this approach. And it was suggested that a more appropriate approach would be to go down a criminal prosecution route. So my main question is, if going through words of advice, if going through a staged response to Section 19, all non-criminal proceedings, the review, non-criminal proceedings, what other alternative could there be that shows a graduated approach? And is it your belief that criminal sanctions are less graduated than civil sanctions?
Well, a great question, because it gives me an opportunity to have another time to speak. But so, firstly, the Regulators Compliance Code makes it quite clear when an enforcement authority is taking enforcement action, it should look at a stepped approach. So, for example, it would be words of advice, informal advice, it could be informal advice in writing. Ordinarily, when it becomes more formal, it becomes first warning, maybe a second warning. Under the Licensing Act, there was a route map that used to be used as a guide, and ordinarily what you would do, if informal words of advice are not working, you would sit down, share information, develop an action plan, and work through that action plan. And if the action plan didn't work, then to promote the licensing objectives, then what you would do is potentially take a review mechanism so that there's a graduated approach. So that's the view in relation to promoting the licensing objectives under the Licensing Act. In relation to alleged breaches, the council have to then follow a different code, which is it's not the Crown Prosecution Code, because obviously it would be a private prosecution, but they would normally decide whether it's in the public interest to, in effect, start formal proceedings. And that can be, for example, with prosecutions for alleged or complaints of alleged crime, you can either take formal warning, simple caution, a local authority caution in effect, a prosecution, but that has to be done in a formal, structured way, where that you would be given notice of the complaint, an opportunity to respond, possibly to a voluntary PACE interview, and then you would take a number of steps. And during that process, the local authority would have to consider the prosecutor's code, or whether it's in the public interest to prosecute. So the prosecution route is very separate to licensing, I would say, looking at a graduated approach to enforcement for review. So on a review, you would take stepped approach, and with a prosecution, you take stepped approach. They're both very different, and normally you would see that occurring. Here, we've got words of advice stepping immediately to review, and that is unusual, members, and that's why I raise it.
Thank you. Further questions?
Yes, Chair, and some clarity, because it hasn't gone from a stepped approach, words of advice, to review. There is also the Section 19, which keeps getting discounted, which was for unlicensed activity. You mentioned that obviously no licensing officer, environmental health officer, or police officer have attended the premises to check in on the late night activity. However, I've clearly exhibited in my statement that there is CCTV footage which shows unlicensed activity occurring with Mr. Ricciardi making hand gestures to the bar staff, making symbols that indicate that he is instructing them to make actions on his behalf. Now, why would I need to attend the premises at 11 o'clock at night on a whim to check in on Mr. Ricciardi when CCTV evidence is available? And do you not feel that that is sufficient to suggest that problems arise that aren't promoting the licensing objectives? She makes lots of reference to it's not a crime, it's an alleged crime. It's not, no one went on to commit crime and disorder. However, do you not agree that by sanctioning unlicensed action or being present while it's occurring, that there is a negative aspect to the promotion of the licensing objectives?
I'm more than able to answer that multiple question and statement. But I would say this, Chair, the words were, and I've written it in my book, that words of advice to review. And so I'm only repeating back that was said in evidence. We know we've got the Section 19, and as I say, I have a different view about that Section 19, and that was never taken to the court in relation to a closure order, as a closure notice. And as a consequence of the notice, the premise licence holder took steps, although I don't think they needed to, but took steps to satisfy the licensing authority. So that shows good behaviour, good management practice, listening, taking instruction. In relation to the point of the witness, witnessing any matters, this is a review asking for quite serious sanctions, removing someone's right to use their back area, adding thousands upon thousands, maybe 15,000 a year in cost, and removing this gentleman's right to be the designated premises supervisor. These are steps that are being asked for, and not one officer has been present, and I think it's worthy to make a note, not one officer has been present from the police, licensing or environmental health to witness any matters arising on a Friday or Saturday night. To say that they've looked at the CCTV and looked at hand gestures, I'm sorry, I've said already that this authority and members, you'll appreciate that you're not here for fact-finding and speculation on what that meant, that hand gesture or not. We're not going through that exercise. And if the officer thought that my client has committed a crime or a breach, then he needs to go through the proper stepped approach rules to go through that so that we can be properly represented, legally represented. Members, it would be wrong of me, and I'm sure you have like your own code of conduct, for someone just to come to council and make a conclusion without you going through a proper process, if it was you personally. Processes and rules are there for a reason, to protect our safeguards. Yeah, although I say that, the world seems to be going awry with some of these rules, but the rules are there for a reason, and that there's no fact finding. I would ask you to be cautious about those types of statements. So no, there hasn't been a graduated approach, and I think I've answered the question that was asked. I would ask that if there are any questions, that they could be maybe a bit shorter and a question rather than a statement, Chair, if I may. And if I'm speaking out of turn by saying that, I apologise. I don't mean to be disrespectful to you in any way.
Thank you. Moving on. Any further questions from the applicants? William.
Mr. Dadds will be pleased to know that my two-part questions, which I took lesson from Mr. Dads himself in asking are finished. Thank you, Chair.
Thank you. Moving on then, do the responsible authorities have any questions for Mr. Dads? Please.
Is
Thank you.
more directed towards the licence holder. I believe William, within his package, made reference to an email that was sent whereby the licence holder admits to making his mistakes and errors, and he apologises. I've not heard any apology today to the committee or any reference to that whereby he admits to making the errors.
Well, Chair, I would. There is an email in there, and I know that the police have, or the licensing authority has comment on it, and I'd be very careful about that because one, it's not done under caution or pace. It's given voluntarily, saying an acceptance of, for example, the suggestion that there's been drug taking. When I've explained to the client about cross-contamination and the proper processes that need to be taken and the qualification that you should hold to make such assertions, he then said, well, hang on a minute, I wouldn't have said that. And I said, exactly, that's the point. You can't be told, for example, you know, with this, I probably would have closed you down, or words to the effect that with 25 complaints, with those, I would have perhaps closed premises down with less. All these sorts of comments that have been recorded, actually, and they're there just in case we need them. But let me say, this type of approach is unhelpful. He doesn't have to come here and apologise. He has come here to explain to the committee that he's listened about the event from the neighbours. He's trying to explain what steps he's taken since the review, had licensing savvy. All these are positive. This is not about punishment. Going forward, he wants to work with you, officer, with William and the environmental health officer to make sure that everyone is happy. Wants to work with his neighbours, and a lot of the community support him and they want to sort of get along. This process of a review, and this is the point, sometimes these reviews like this, without taking a graduated approach, in effect drive a wedge between the parties. They're very unhelpful. That's why, Chair, they say that's why that you have a graduated approach to try to avoid what was described that it can be tensions. We don't want those tensions. We want to promote the licensing objectives and want to work with the committee. But clearly it's the committee that will decide the facts.
Thank you. Any further questions from the responsible authorities, please? Yeah.
No, thank you.
And from Environmental Health, any questions?
Yes, I've got just one question. Our records show in the past the premises licence holder has worked with a noise consultant. We obviously have touched on today, there was quite a few complaints around the August bank holiday event. Was advice given by the noise consultant ahead of this event, and what was that?
Thank you for asking that question. What the noise consultant has given some advice around some acoustic fencing. So acoustic fencing has been constructed, so that's been undertaken, and that's been there from the get-go. Noise measurements have been undertaken in that area and around, and that he's satisfied that actually there's no noise breakout from the premises or that area that would in effect cause a public nuisance. So we are taking advice, and in fact there is a machine there at the moment taking measurements, and has been since this review should it be required. Now those measurements have not been put into the committee, but we are satisfied that actually that garden area is being used appropriately within proper restraints. We recognise that the event over the August bank holiday was or has caused a nuisance to some of the neighbours. Obviously, some of the neighbours were there and they enjoyed it, so it wasn't causing a nuisance. So there is a balance to be had, and it's no different to when you have different celebratory year. Like there's a complaint in one of I'll do this one. I've clearly been talking too much. Sorry, Chair. For example, there's a complaint in one of the logs for New Year's Eve. So I think one's got to be recognising that what some people will want to do and go and enjoy establishment, others will not enjoy, and it's about striking that balance. And we are happy to work with you and your officers and your colleagues with the noise engineer that we have to share information that we've got, but we believe that the use of the external area is okay and acceptable, and that we're happy to share that information with you if one of your colleagues wants to come down and join us.
Okay,
Thank you.
can I just bring it back to the specific question around did you seek advice before the August Bank Holiday event? I know we've sort of talked in the past.
Yes, so as I understand it, the advice was about the garden, and because before that event there'd been some complaints, so we'd erected an acoustic fencing, so that's been done, and there is monitoring of that. Now, in relation to the outside use, so there was advice in relation to outside use. When it used to be the old RAF club, they used to have regular events outside, and we know that they were regular events, and they went on, as we understand it, without complaints. So therefore, that's why we thought we could do an event without hopefully anyone being concerned. So advice was given insofar as what treatment we could do to offences, levels of music, but other than that, that's as far as I can go.
Okay, thank you.
Thank you. No further questions? Thank you. Do any of the other interested parties have questions, Mr. Dads?
Yeah,
please.
hi. Yeah, I'd just like to say just a few points for the record, please. So, just questions, okay. So, can you tell me on what dates the requests for mediation went out? Because I've never seen any, and certainly haven't refused any. Secondly, did the noise consultant really advise that you make acoustic, inverted commas, fencing from some leftover fence panels and some spare polystyrene? I'm not sure really that really cuts it.
Chair, I don't have on hand the dates, but I've spoken to the noise acoustic engineer, who is, I think, a member of the Institute, and he tells me he has reached out. Now, if there's somehow some miscommunication between them, I'm glad to possibly try to assist Mr. Alott and the noise engineer acoustic engineer to speak to each other, because I think it is important if we can get some communication, dialogue, and working together. That will be much better for everyone that's here. So if he's willing to work, have communication with each other, we're happy to do so.
And any comment on the nature of the barrier that Mr. Alott refers to?
The fencing is acoustic fencing. So at the end of the day, it's been advised, it's been erected. It's not thrown together pieces of wood as described. Look, I want to get away from that emotive language. It's been done professionally. I've been there today and had a look. I've spoken to the engineer and he's explained what has been put in place. I can't comment any further than that, Chair.
Okay, thank you.
Yeah, another question.
Further questions, yes, thank you.
Yeah, you refer to how many events the RAF Club had previously compared to the current owner. Personally, I feel you might have overplayed that. So could you clarify with numbers how many events annually did the RAF Club used to have compared to the continued weekend use every weekend compared to the Lancaster Lounge, please?
Well, Chair, in relation to what I've said, it's about the outside garden, outside space. We've only used it once for an event, as I understand it, whereas the other premises before, when you might say it's not relevant, would use it often. I wouldn't say any more than that. And I think Mr. Alott's own family member has played the drums there previously. So we know that it has been a premises used for live music and for music outside.
Thank you. We don't know any precise numbers for the previous use under the RAF Club. No. Okay, thank you.
Certainly more than one. We've only had it once, and we're not going to do that again. And we're quite happy to have in the sense of that event, but we obviously we do use the outside garden and do have the area, but that event, we're happy to have dialogue with Mr. Aylott to work out what we want to do and work with him, because the community do want these types of events. They do want to go out and have some fun, and they do want to have somewhere where they can have August bank holidays and bank holiday weekends where they have some enjoyment. And we're not here. Society recognises that people want to go out to licensed premises, and it is about a balance. And we would say, even at bank holidays, even once or twice a year, Mr. Aylott may feel he's disturbed, but that is not, that in itself would not be a public nuisance if there are a number of events a year where that he may be inconvenienced, because at the end of the day, he does live next to a licensed premises.
Yeah, can I just say, coming back on that, you really are trying to minimise this. It's just not true. Okay, so you need to come back then with numbers. Okay.
Thank you. Ms. Clark, you have a question, yeah?
I just wanted to answer one of the questions, if I could. So I was on the committee at the Rapper Club,
Okay, thank you.
and I do know that there were quite a few events outside in the garden. Quite often there was a live band. There was also discos, they had beer festivals, so there were quite a few.
Thank you for that. Any other questions for Mr. Dadds from any of the interested parties? No? Okay, thank you. May I now invite the applicant, clearly, to sum up the application for a period of no longer than 5 minutes, not introducing, obviously, any new evidence to the proceedings at this point. Thank you, William.
Thank you, Chair, and thank you to everyone today. I know this has been a very long session. I would like to reiterate that despite what has been discussed, I have, in my opinion, professionally taken a graduated approach. The purpose of my review today is because I do feel that the unlicensed activity, the breach of conditions, and everything that's been discussed within my statement in today demonstrates that there is a pattern of behaviour developing at the premises which could lead on to further problems. I've respectfully asked the committee to take regard to the suggestions I have made. Obviously, it's within your gift and power to ignore those, to consider those, to alter those. They are simply my suggestions of things that I believe will help mitigate the extended risk that the premises presents. And I do believe that this activity and all of the evidence presented, specifically the CCTV, which you have availability to view, shows the sheer extent of this event. And basically, I just believe that the licensing objectives, which are the core focus of today's review hearing, have been negatively impacted, and unless proper sanctions are taken, will continue to be impacted. And that's all I have to say today. Thank you for your time.
Thank you very much, William. So before we move on to item 6, which is exclusion of the press and public... Sorry.
To give everyone a chance to sum up. So, please, EH, Mr. Dadds, Ms. Clark, Mr. Freeman.
We normally, because we got the most to lose and where the premise licence should go last, I don't normally get to go last at home.
So, please.
Thank you. I've got not a lot else to add. I think William summed it up really well. All I can say is I think the current operator is quite inexperienced. I think that's come through his operation of the premises up to date, hence his further training and doing licensing savvy, etc. And probably the review has pushed him in that direction. And that's it from us. Thank you.
Environmental health?
Thank you. I'll keep it sweet. So we've obviously recommended some conditions. I think without putting those on, I believe that the complaints that we've had about the premises will continue, and we'll still be required to fulfil our statutory duty under the Environmental Protection Act to investigate those in terms of noise nuisance. And if steps aren't taken to restrict the outside area or the playing of amplified music out there and the noise management plan elements, that we will be potentially in a position where we establish that a nuisance is being caused.
Thank you. Who else should be going?
Mr. Aylott.
Mr. Aylott, would like to make a concluding statement.
Like I started in my first, when I was given some allotted time, I've lived next door to licensed premises for the last 35 years. I've never had any problems with any of the premises. There has been a step change. It has been out of hand. It has been exceptionally badly managed. There's been no attempt at mediation. And not only myself, but several neighbours are sick to death of it. Please, can you do something about it?
Thank you. Ms. Clark, Mr. Freeman, do you wish to make a concluding statement?
No, thank you, Mr. Chairman.
Thank you. Just summing up.
Yeah.
In relation to this matter, we've got the officer suggesting that there's a graduated approach, and I'd ask you to find that there hasn't been. But notwithstanding that, we don't want to fall out with him. We're happy to work with him and his department, and it's not personal. We believe that there is no pattern of behaviour that increases the risk. There's been no risk because actually there's been no crime disorder. I know that there's been a complaint. There's been no witnessing through the statutory authorities any matters arising. The complaints that we've received in the last 6 months, maximum are 8 in total, which are not corroborated. You've heard from Environment Health the numbers that they gave: 2 in June, 1 in July, 4 in August, I think, or a little bit less, and 1 in September. But overall, I've been given numbers beforehand that there's a maximum of 8, predominantly around the August bank holiday there were 4. But it's typical one a month over the summer months, and that's not been corroborated. And that in relation to the suggestions to help risk, we say that actually what we've done to address the concerns raised is go through a very protracted licensing savvy accreditation and work. I know Don won't mind me saying this, that he's been working really hard to go through that process. It is a learning curve, and he has taken additional steps to go to an accreditation which is much harder and that would be ordinarily required. He has gone in effect to all but Mr. Aylott residents to engage with them. All the residents across the road have all written into support. So the immediate neighbours, except for Mr. Aylott, have actually written in letters of support. And there are hundreds, in effect, of individuals in support through the petition and through letters. You've had 54 received, 64 rejected, but you still know there's 114 residents written in support of this premises. That speaks volumes, members, and I ask you to take that into account. And in relation to environmental health, they haven't witnessed anything personally themselves. They haven't issued a noise abatement notice, and that they've in effect paused their normal process because of this review. And they are not prevented under the Environmental Protection Act 1990 to follow their normal statutory rules and provisions. And I would say to use the review process to usurp those normal processes would be wrong. And that given the very little numbers of complaints which are not corroborated, I would say that it would be disproportionate to reduce the hours of the garden use. And there are additional mitigating measures that we've put in place about supervision and CCTV with audio. There are a number of provisions that we have done to make sure, and sound monitoring, to make sure that that area is not causing a nuisance to its neighbours. One neighbour is the fire station, Mr. Aylott is the other side, and at the back, far, far back, are some neighbours which we've actually been engaging with. I think Rose, we've been engaging with her, and she is satisfied with what we are doing. So we believe we are working very well with our neighbours, working well with others, and we want to do the same with Mr. Aylott, and hopefully after today we can do that. There's nothing to prevent you, members, from giving words of advice, even a warning regarding about what you expect going forward. I would just say one thing though, is that the licensing officer says that in effect there should be a sanction. And that's my point. I think he used the word sanction. And the Licensing Act isn't about punishment. And that there should be no finding of fact in relation to alleged breaches. There should be no sanction, no punishment. It's about promoting licensing objectives. And we think by doing the licensing savvy, reflecting, speaking to our neighbours, we think we've done all that's necessary to promote the licensing objectives. Thank you.
Thank you, Mr. Dadds. Move on. Thank you. So before we move on to item 6, exclusion of the press and the public, the subcommittee will now retire to deliberate. The Council's legal advisor will provide legal advice and to record the subcommittee's decision. We're unclear how long deliberations will take. Our decision will be sent out to you all in writing as soon as possible. Within 5 working days. Yep. So all parties do have a right of appeal to the Magistrates' Court within 21 days of the decision. Luke, is there anything you want to add? No, thank you. So that leaves me to thank you all for your attendance today. We will now move on to item 6, exclusion of the press and public. Members, are you happy to exclude press and public?
Yes.
Thank you. That's approved.
Thank you, Mr. Chairman. Thank you for your time, members.
Thank you. Stop the